Welcome to the Cafe Culture podcast, a season of discussions on culture, politics, philosophy and science.
Hello, nice to meet you all. Thank you for coming this evening. I hope my theory is of interest to you. It's just about to go off for publication, but there's still time for any comments and questions. So if you have any, I'd be delighted to hear them. So what I'm going to talk about is the Human Rights Act, its sort of reception into the UK, and why it's had more of a rougher time perhaps than Bill of Rights in other countries. So, since not long after its creation in 1998, the Human Rights Act, which brought the European Convention into British law and for the first time enabled individuals to bring a claim in British courts that their human rights had been interfered with. Well, since not long after it was sort of created, it's faced criticism and calls for its repeal. The most common criticisms have been that it gives insufficient prominence to rights, to responsibilities and to duties. The Labour government in 2009, they conducted a review of the Act, and they said that duties and responsibilities are deeply woven into our social and moral fabric, and they felt that the Act and its enforcement had given too much emphasis to individual liberty. A cross-party commission on the Bill of Rights in 2012 found that there was a lack of ownership of human rights in England, and the current government, in their recent manifesto, committed themselves to replacing the Human Rights Act with a Bill of Rights and Responsibilities, although no time frame for doing that was ever forthcoming, and it seems to be deep in the long grass, which I'm quite happy about. So what I will try to show to you this evening is that the criticism and the lack of acceptance of human rights in England is, at least in part, a consequence of a fundamental conflict between different conceptions of human identity, how we understand what it is to be an individual human being. These conflicts are between the theory that the individual is defined by their choices, and this is the idea of the individual that underpins the European Convention on Human Rights and most other international rights documents and most other national constitutions. And against that, there is a conception which I argue underlies the British Constitution. And the British Constitution, I think, has long defined individuals not by their choices or their capacity for choice, but by the duties they owe. Okay? So I will argue that how we predominantly understand ourselves as individuals in the UK, our identity, our relationship with the state under the Constitution, being defined by the duties we owe, is incompatible with the idea of what it is to be a human, which is sort of underlying the global human rights movement and what the European Court has sought to protect. And this is why human rights have had a sort of tough time in the UK. There's this conflict between two fundamental different understandings of what it is to be human. So, as you probably all know, the British Constitution is unwritten, and which is one of the reasons we've had so much fun trying to work out who can invoke Article 50. And you've had the two cases in the High Court and then the Supreme Court trying to basically work out what is our Constitution. And they look down the back of the sofa, but eventually they've managed to work it out, okay? But that's because it's not written down in any single document. It's composed of lots of different ideas and lots of different documents. We've never had a sort of full-scale revolution which has permanently overthrown the established order and necessitated the writing of a constitution which sort of sets out who exercises state power and, importantly, the fundamental basis on which power is exercised. As a result, our constitution has evolved slowly for more than 1,000 years. You can trace a line from the constitution we have today all the way back to before Magna Carta. I'll talk a bit more about that later. So the current rules of the Constitution still have their original basis in the idea of the divine right of kings, which you may remember from your history and reading your Shakespeare and things like that. Now, this is the idea that the king is God's chosen ruler, divinely appointed to rule, and as such, the subjects, us, have a fundamental duty to obey him or her and therefore the laws he makes. That is the original foundation of the British Constitution, who has power and the basis upon which it is exercised. This foundation you can see that in some really lovely poetry written by the Saxon King Alfred, which I came across as part of my research. But yeah, fundamentally, we as individuals are still regarded under the British Constitution, and I would think seem still to largely regard ourselves as defined by the duties we owe. We no longer, most of us regard ourselves as under a religious duty to obey the sovereign. But nonetheless, the core parts of the British Constitution do view us, the individuals, and I do think we regard ourselves as defined by the duties we owe, not by our freedom to choose how to live. We may freely choose how to live, but I think fundamentally we define ourselves in terms of the duties we owe. So, if you're sitting comfortably, and most of you look like you are, and you've had lots of coffee and cake, I will sort of walk us through tell the story of how this duty conception of the individual is the golden thread running through the tapestry of the British Constitution to the present day. So, Magna Carta, okay? Sealed between King John and the barons in 1215, traditionally regarded as the source of the protection of the individual freedom that we have within the UK. And although it is largely repealed, and it says very little to anybody who isn't a king or a baron, it does contain some important provisions on the right to fair trial, so there are some things that we can now consider as protected by rights in there. However, implicit within it is this divine right of kings' duty understanding of what it is to be human. The justification it states for obedience to the rules it contains is because it was God's will. Individual subjects are barely mentioned. Within it, the identity of all, the king, the barons, the freemen, they're all defined in terms of the duties they owe. It's not like a Bill of Rights which sort of says you have the freedom to do this, that, or the other. Every rule in there is sort of defined in terms of somebody owing a duty to somebody. Barons to the king, king to God, and so on. Okay, so this duty idea of the identity of the people described within it is very much in there. The same is true of the source and substance of the protection within the Bill of Rights of 1689, signed off by William of Orange. Although titled the Bill of Rights, the foundational conception of the individual within it is one defined by duties. The bill, yet again, sees the authority of the Prince of Orange to be that which it hath pleased Almighty God to make the glorious instrument of delivering this kingdom from popery and arbitrary powers. They don't write bills like that anymore. Great, I think. They use a lot more commas, and in some laws they're just basically a paragraph without a comma, and you just have to put them in for yourself. It's like dot to dot, only you're adding the dots rather than joining them up. So although the Bill of Rights talks of rights, these are stated as subjects' rights, and to me that seems like two ideas that are in conflict. Okay? So you're a subject of a duty, but a subject with rights. It's still this idea of duties underlying. So, and even these are held by people who are primarily characterized by their duties, not their capacity as rational beings to freely choose how to live. Now, these documents are old, and Britain has come a long way since then. However, this understanding of the relationship of the individual and the state and how we understand ourselves as individual, I think remains predominant in England and underpins the criticisms of the Human Rights Act. So if we move more up to date, though still in the 19th century, we very much see the idea of the individual as defined by their duties, clearly underpinning the Constitution. So Walter Bagehot, in his rather juicy book, The English Constitution, available from a bookshop very near you, in there he argues the influence of history upon England, upon the common idea of our national character cannot be exaggerated. I think he's right. He describes the people of 19th century England as a deferential nation who fundamentally see their relationship with power of the state as defined by the duty they owe to the Queen. He states our constitution is not based upon equality, but upon certain ancient feelings of deference of individuals to state power, rooted in the easily grasped notion of a duty to the monarch who is divinely anointed by God to rule. Now, that was in the 19th century, but in British law, the individual was still defined as a subject, not a citizen, until 1947. So how have things changed? Let's come up to date. So think for a moment, what does the British Constitution mean to you? Okay, what do you see as the main elements of it? Can somebody give me an element of the British Constitution? Parliamentary sovereignty. Thank you very much. So, parliamentary sovereignty. Sovereignty, parliamentary sovereignty. So, if you're following the Brexit case closely, you will have seen the High Court in that case. They stated parliamentary sovereignty is the most fundamental rule, of our Constitution. That's what they said. Don't blame me, it was the High Court. Thus, fundamentally, the ultimate principle of the Constitution is a duty on all to obey the decisions of Parliament. It is not life, liberty, and the pursuit of happiness. It is not liberty, equality, fraternity, and is not human dignity shall be inviolable. To respect it shall be the duty of all state authority. Unlike America, France, or Germany, from whom those things I just mentioned are the founding statements of their constitution, there is ultimately, currently, no constitutional grounds on which a citizen or a court can hold themselves not to be bound to obey Parliament's laws. There's no basis on which you can ultimately challenge the validity of a parliamentary law. Okay? You have a duty to obey it. That's what the British Constitution says. The High Court several months ago. Another rule of the British Constitution. Royal prerogative. Oh, I haven't got that one written down, but it's good. Yeah, I can do that one. Okay. Royal prerogative, possessed by the executive, inherited from the Queen. Okay. With the government claiming to act in the Queen's name. I think that fits quite nicely with this idea of the duty of the sovereign. To give Parliament its full name, it's not parliamentary sovereignty, it is the sovereignty of the Queen in Parliament. Okay, so we've still got this idea behind the scenes of duties to the Queen. Another element of the Constitution, anyone? Pardon?
Lack of consistency.
Lack of consistency, excellent, I like it. Well, I would argue that duty is the consistent principle. The other one you could have got for a bonus point, I would say the rule of law. But I have a colleague in the audience and he wasn't going to go for that one for some reason. I'm going to ask him why later. But yes, so the rule of law. But this ultimately says that, it only says that we're all bound and entitled to the benefits of the law. In its most basic sense, it says all must obey the law. So these are the foundational principles of our Constitution. Okay, yes, sir? Separation of powers. I can do that one. Okay. What is the basis for our separation of powers? Well, for a long time we didn't really have separation of powers. It's all been sort of, and arguably we're still losing it. I mean, so it was in Parliament, but then the judiciary were in the House of Lords. The Lord Chancellor was also a member of the Parliament. The executive, the other branch, very much part of the legislature, and some would argue controlling Parliament. So yeah, so still all in there, but that's sort of, those separation of powers, a key principle of our Constitution, but still within there is this obligation of the individual in relation to the separation of powers to obey. So, the principles of our Constitution reflect an understanding of the relationship between the individual and the state, and the understanding of ourselves as defined by the duties we owe, not our freedom to choose how to act. This is deeply rooted in the conception of the individual, that human rights challenge. And it is for this reason that human rights have encountered controversy in the UK. Okay? So the conception of the individual underlying international human rights law, the European Convention on Human Rights, is of the individual as fundamentally having the capacity to choose how to live. That's what they protect. And you can trace this back to the sort of development of the human rights movement in the 18th century, in the revolutions of America and France. These revolutions were ultimately a rejection of the duty idea of what it is to be human, in favour of one which recognized our capacity for freedom of choice as to how to live. And it was from these that the idea that we have of human rights internationally live. So both of these revolutions, the French and the American, overthrew a monarchical system and created constitutions and rights documents grounded in the idea of an individual with the capacity to freely choose how to live. You can see this in the United States Declaration of Independence, where they say all men have an unalienable right to life, liberty, and the pursuit of happiness, and that to secure the rights, the governments are instituted among men, and this is the important bit, deriving their powers from the consent of the governed. Okay, so they no longer have this divine right of kings idea. The reason for the government is because it gives effect to the capacity of the individual to choose how to live. And it goes on to say that the right of the people to alter or abolish the government if it becomes destructive exists. So again, this idea underlying the American Declaration of Independence, the American Constitution, of the individual capacity to choose how to live, not the basis of the British Constitution at that time, and arguably still not. So this idea of the individual as ultimately possessing the capacity to choose how to live is the basis for the more modern human rights documents, the Universal Declaration of Human Rights and the European Convention. If you want some evidence, okay, of the influence of this sort of underlying constitutional idea on how people see themselves as individuals, I found one thing I discovered is you can look at World War II and World War I recruiting posters. Okay? If you Google war poster, United States and freedom, and then do the same thing and substitute duty for freedom, you will get one poster that talks in terms of duty and quite a lot more that talk in terms of freedom. If you do the same thing only with the UK rather than the United States, you'll get a lot more posters that talk about duty and only one that talks about freedom. And I think this reflects, certainly at that time, how the individual understood themselves as a person, primarily defined by their duties, and their relationship with the state in the UK, and then conversely in the United States. And I think that is a result of the influence of the Constitution. I'm not sure which way around it goes. It's probably a sort of circular. They both reinforce each other. It's the basis of the two societies. If there are any West Wing fans in here, there's another good example. The episode where they get the Republican lawyer to come in to work in the White House, and they talk about Gilbert and Sullivan a lot. And they say, well, they're trying to work out whether it's HMS Pinafore or Pirates of Penzance. And one of them says, well, it's the one that's based on duty. And somebody else says, well, they're all based on duty. Okay? The underlying theme of Gilbert and Sullivan was duty to a large extent. And that, again, reflects our understanding as individuals. Or at least it did back in the Victorian time. But okay, let's come right up to date. Okay, so until the Human Rights Act, the duty conception of the individual in the UK had never been directly challenged and replaced with a founding conception of the individual defined by freedom of choice in the way that it was in sort of the United States or France, or by the need to create some higher law against which the state's actions can be judged, as was the case in post-World War II Germany. Now, prior to the Human Rights Act, there was and there has been a slow movement away from this duty conception of the individual. Okay, it has slowly been worn away. There was never this sudden sort of ending like the American Declaration of Independence or the French Revolution or anything like that. We never had that big break and the creation of a new constitution with a new basis. So you can see this duty idea being chipped away at. Okay, so post-World War I, you of course get universal suffrage. 1927, if I sort of remember for everybody. And then after World War II, you get this change from subject to citizen. Okay, but nonetheless, the idea of the individual as primarily defined by duties remains. We developed the idea of civil liberties, which preceded the Human Rights Act and gave some of the protection that the Human Rights Act now gives. But the idea of civil liberties ultimately reflects an understanding of ourselves and a relationship with the state as defined by the idea of duty. I mean, civil liberties say parliamentary sovereignty, the rule of law, they're the starting points for civil liberties, okay? Civil liberties at their heart say that you are free to do whatever the law doesn't prohibit. Only after your duties to obey the law are satisfied, then you're free. But freedom wasn't the starting point. You couldn't go to court and claim a particular freedom. We just didn't have the causes of action. That was the big change that the Human Rights Act created. It enabled you to point to a right on the list and say, okay, court, this is my right. You have to give effect to it. Okay, so there have been slow changes and slow nibbles away at this duty basis. In 2005, the decision in Jackson versus Attorney General, which concerned fox hunting, which isn't relevant for the purposes of this unless a fox happens to wander in which case that would be splendid, as I've never had a fox in the audience, to my knowledge. But anyway, no, to get back to that. So in that case, that caused great excitement amongst lawyers, who are very easily excited. And two members of the House of Lords suggested that the courts might, just might, refuse to enforce an act of Parliament which obliterated fundamental rights. So they didn't do it, but they suggested that this might be possible. They sort of fired a shot across the bows of Parliament and of the government. And I think that shows us sort of, again, a nibbling away at this duty foundation of the British Constitution and the duty idea of the individual within the UK. Now, I've talked a lot about the UK, but what I said in my introduction was I was going to talk about England. Now, the 2012 Commission on the Bill of Rights only found a lack of ownership of human rights amongst the people of England. They did a survey of all the UK, and they wanted to work out, why aren't these popular? I mean, they like them in lots of other countries, but they're having a bit of a rough time here, and we want to try and understand why it is. And I think that the reason they haven't come in for the same criticism in the other parts of the UK was that the Human Rights Act was enacted at exactly the time as devolution happened to the rest of the UK. And I think the process of giving the people in those parts of the UK the choice as to how they were governed changed the way the people of those parts of the UK understood their identity as individuals. Their capacity to choose how to live and how to be governed was recognised by the law and by themselves. The devolved assemblies are more strictly subject to human rights than the UK Parliament, but yet that doesn't seem to be the problem for the people in the rest of the UK. There isn't the same hostility. And I think this perhaps reflects the fact that the creation of devolution changed the relationship between the individual and the state for them, their understanding of it, and their understanding of themselves as individuals. They were given this choice. So perhaps Brexit will have the same effect in England. Okay? Perhaps voting to take back control shows a rejection of our previous understanding of ourselves as individuals defined by a duty to obey. Perhaps through the act of voting in the referendum, there was a wide recognition that fundamentally individuals have a capacity to choose how to live and how to be governed. They need not simply obey. Perhaps we understand the relationship between the individual and the state has changed. I don't know. We shall have to wait and see. Perhaps it will lead to a greater acceptance of human rights and the recognition that they protect our capacity as individuals to choose how to live. Perhaps it could lead to a constitutional convention and a new constitution which has a different basis, a basis in individual freedom to choose how to live. Maybe. Hope springs eternal. We shall see. So I would ask you to ask yourselves, am I ultimately defined by the duties I owe or by the choices I make? Our constitution and traditionally our government view individuals as primarily defined by their duties and primarily owing obedience. Duties are the natural flip side of rights. If I claim a right against someone else, necessarily they have to have a duty. But what matters is the perspective from which you start. If you start from the idea of the individual as defined by duties, then rights, or civil liberties as they really are only what the state generously decides you should have and offers no claim for protection against a majority. If you start from the idea that the individual as fundamentally having the capacity to choose how to live, then duties are only those things which are necessary to give effect to that innate capacity to choose how to live, which human rights protect. Thank you very much.